All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And we're going to start our docket this morning with People v. Crystal Radursky, filed 2015-5073 FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
Matt Border for the defendant, Your Honor.
Good morning, and this is your petition for Ms. Radursky, or did you go by Brubaker now?
Brubaker.
Ms. Brubaker's petition to set aside a conviction from 2015. Looks like I had this reapplication. I had denied it like 3 years ago and told her to come back in 3 years. Is that right?
Yes, Your Honor. I think it was 2 years, but
Okay.
Regardless, you found her to be eligible 2 years ago, but you wanted some more water under the bridge
Sure.
to make sure that she had that track record.
Okay.
And she does now, and so we can take some testimony as to the last couple of years if you'd like.
Okay, very good. Ms. Brubaker, if you want to come on up to the witness stand, please. And as you arrive, please raise your right hand for me. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Okay.
All right, could you state your name for the record?
Crystal Brubaker.
All right, and was your last name previously Radursky?
Yes.
So you're the defendant in this case?
Yes.
Okay. 2 years ago, you came to this court for an expungement, is that right?
Correct.
Did you also file an application to set aside a conviction in district court in the same building?
Correct.
Now, that application was granted, correct?
Yes.
And this one was denied, but you were told you could come back?
Yes.
Okay. Since that time, have you been charged with any crimes?
No.
Have you been convicted of any crimes?
No.
Do you have any charges currently pending in any court that you're aware of?
No.
Okay. How are you employed these days?
I'm a nurse.
Okay. And for how long have you worked in that capacity?
8 years.
Okay. Where do you work?
McLaren.
And in what medical area do you work right now?
The med surge floor.
How long has that been?
2 years on that floor.
And when you say med surge, you mean surgical?
Yeah.
Okay. And do you have any children living with you at home?
I have 4 girls.
Uh,
Plus a grandbaby.
okay. And what are the ages of the people living at home with you?
23, 22, 20, and 11, and 3-year-old grandbaby.
Do the ones in their 20s work?
Yes, they do.
Do they still depend upon you for support to some extent?
Yes, they do.
Do you have anyone else in the home that's providing that support?
No.
Why would you like to have this application set aside?
I'd just like to keep furthering what I'm doing. I got my bachelor's, possibly get my master's, maybe nurse practitioner, but things are.
With this conviction on your record, is that something that you'd be able to pursue the advanced degrees and advanced certifications?
I could get the certifications, but then getting a job would be
Okay.
hard.
All right. And so you'd like to have this set aside so that you can improve your standing professionally.
Yes.
And financially.
Yes.
Okay. Judge, I don't have any further questions.
Thank you. Any cross exam?
No, yeah.
You can step down.
Thank you.
Argument, Mr. Boyer.
Your Honor, under the circumstances, she was qualified 2 years ago. There's been nothing that's happened since then to disqualify her. In fact, her actions have shown there's been that water under the bridge to show that she's not going to reoffend. No issues in that regard. And so we'd ask that you grant our motion to set aside.
Okay, thank you. Ms. Goodrich.
Your Honor, we received the Attorney General's confirmation that she is eligible on February 24th of 2025. Also, we show no new convictions, so we would stipulate to the relief requested.
All right, well, Ms. Brubaker, I'm sure it was a bit of a disappointment when you came a couple of years ago, and I said, no, I just, the district court matter that has also been set aside was just a little too recent for me to feel and a little too similar to this case for me to feel comfortable. So I had to wait a couple of years. You've come back after the time I told you to wait, and you've not had anything that's happened in those 2 years that would cause me any concern. So I do find that you're eligible to have this conviction set aside. the Attorney General's been given an opportunity and the prosecuting attorney to contest the application. They do not. And I also find, based upon your testimony today and my review of the record, that your circumstances and your behavior warrant setting aside the conviction, and that doing so is consistent with the public welfare. So I'm granting your petition and setting aside that conviction.
Thank you, Your Honor.
And Mr. Gauthier, you can present an order.
I will. I had one with me. I had one, but I left it on the printer this morning.
Okay.
So
Okay,
we'll
very
get it
good.
sent to you, and I'll run it by the prosecutor for approval.
Okay, very good.
Thank you, Your Honor.
Good luck to you.
Have a good day.
All right, and next we have People v. Robert Bradshaw, file 24-6937 FH. Counsel, you want to state your appearances, please?
Melissa Goodish, Wayne County Prosecutor.
John Pyle, I'm here for Mr. Bradshaw, attorney for the defendant.
Jonathan, what's your last name, sir?
Pyle, P-Y-L-E.
P-Y-L-E, okay. All right, and you're with the same firm as Mr. Penanti?
That's correct.
All right, and Mr. Bradshaw is okay with your appearance here today on his behalf? Okay. All right, this is, the matter is set for jury trial on June 2nd. The prosecutor has filed a notice of other acts of domestic violence under the statute, and the defense has objected to that. The prosecutor's filed an answer to that objection, and so we're here to hear argument on the defense objection to the other acts evidence. Mr. Pyle, go ahead, sir.
Thank you, Your Honor. I'm not sure who the burden lies today, as I believe they're the proponents of the evidence and seeking to introduce it. So I think at baseline, they'll have to show some baseline to get that in. For today's purpose, we're dealing with primarily 3 alleged other acts. 2 are quite similar in time and share the same victim. A third is more recent and shares the victim with the present current case. So I think they can be talked about kind of separately. The 2 older incidents, those are over 10 years ago. So I do not believe the statute allows those to come in. They could come in theoretically if they were required. However, they can only be allowed in for a very limited purpose if there is an exception, which here, the only exception that could possibly apply, I think the parties all agree, would be the interest of justice. And really what that boils down to is this needed to keep the jury from being misled? Here, the incidents that we're talking about, one involves a bat, the other involves choking. Both involve an allegation that Mr. Bradshaw kind of hounded the victim around and was physically using his body and other things connected to him to forcefully assault this person.
Can I ask you a question about that? The interest of justice exception, which I understand should be narrowly construed to make the 10-year limit generally effective. And if there's an allegation of domestic violence and the defendant says, well, I didn't do it, then piling on with all of these things from more than 10 years ago, can be considered under the statute sort of piling on. But what am I to make of the prosecutor's argument that, well, this is an interest of justice exception because the defense is presenting a very specific defense, self-defense. And in order for the jury to have an accurate picture of whether this defendant was acting in self-defense or as an aggressor and a domestic abuser, it's necessary for the jury to have a full picture of his history of domestic abuse. What am I to make of that argument?
I think the court or the legislature was pretty specific for a good reason. The piling on can occur even with a conviction. Just because somebody had a conviction in the past does not mean at present they are still that same person. And I think that's where the time frame really comes into play, is that 10 years. And here, there's nothing unique about a self-defense claim. That's a pretty general claim of I was under fear. The responding act was different in both cases. Here, the allegation is something was tossed back and forth.
What about, so you make a good point about maybe the 10-year limitation is because someone today might not be the same person they were 10 years ago. I think that there's certainly some common sense and lived experience merit to that position. But in this case, we've got, if we had prior convictions from 2013 and 2014, and then nothing until now, that would have some weight to say, well, gee, this defendant is not the same person he was 10 years ago. But we also have a conviction within that 10-year window in 2023. So wouldn't that cut the other way to say he's the same person he was 10 years ago? He's got convictions of domestic abuse over a period of time prior to 10 years ago and within that 10-year window. What evidence do I have to say, well, he's a different person now?
I don't know that you necessarily have evidence here before you. Certainly that would cut against our position. However, I think the rule is pretty clear in that it requires an exception. So the default is that it's not allowed. And it really would only be needed if there was some sort of common plan or some sort of identity issue. Here, there's no doubt about the parties. There's no similarity in some sort of common plan. Claiming a self-defense claim alone does not necessarily create a similar circumstance. A person being intoxicated and violent, similarly, that's the basis of the statute, is an assault. So the only similarities here are really intoxication and the statute itself. The form of assault is entirely different.
Yeah, I would tend to agree with the defense that absent the statute, this is not the kind of similarity that would make it a common scheme or plan to be admissible under 404B. The case law requires some kind of striking similarities. I don't really see that here. But we're really left with the statute where the legislature's decided that propensity is allowed. Okay, so that's your argument as to the older than 10-year convictions. What about the 2023 conviction with the same victim?
The 2023 conviction, we would argue, I guess, a couple things. We would first argue that the entire record should not come in with the register of action. That would provide much more information than the statute specifies. The statute allows for the other acts, which the prosecutor has stated a conviction would be evidence that another act occurred. However, I don't know that the register of action and all the ancillary information should be submitted to the jury on that. Really, the basis of that conviction, the reason we believe it should be kept out is it is extremely prejudicial when you're talking about someone being choked compared to an object tossed in the direction of somebody or thrown in the direction of somebody. The idea that somebody could be committing this egregious crime, which the legislature, again, has on that, a choking case has put an extremely high penalty compared to what we're dealing with here, which would be a 93-day offense, but for prior convictions. So I think it'd be incredibly prejudicial to allow any testimony of those prior acts, because I think the jury would be likely to take that into consideration and completely judge him based on that circumstance and not really be able to focus instead on the simple circumstance here at hand. So with that more recent conviction, I think ultimately the law is what the law is on whether or not the conviction itself can come in. However, I think the backstop to that is that this is incredibly prejudicial and not at all similar in the circumstances. The only similarity here that I see is an allegation of intoxication, really.
Okay. All right, thank you, Mr. Powell. Ms. Goodrich.
Your Honor, as to the 10-year argument, I do believe that the jury would be misled if the 2013, 2014 convictions were not admissible. There's a clear pattern here of him in a relationship back then and acting out violently that causes court intervention that he pleads guilty to. The two instances are 1 year apart. And then again, in this relationship that he's in, the instances are 1 year apart and he acts violently in both cases, I think. And additionally, with the self-defense, he alludes to that in review of the police reports of the older cases as well as the newer cases. And even in the objections under the intervening acts, the defendant alludes to trying to say those other cases involve self-defense. So I think that it would be important for the jury to know that this is what he does when in a relationship with somebody.
Okay, thank you. Any rebuttal argument?
Just that all those similarities are what the statute itself is, other than the intoxication in a relationship required. That's a statutory thing. That goes nothing to this test. Otherwise, it would not be part of it because it's statutory. Beyond that, a violent act. That's what domestic violence is, statutory. So there's very, very limited similarities other than intoxication and some claim self-defense, which is broadly claimed in many assault cases.
All right, thank you. Well, under Michigan compiled law 768.27B, the legislature has allowed for evidence of other acts of domestic violence to be admitted in a trial for domestic violence for any purpose for which they would be relevant. The rules of evidence would generally render other acts evidence inadmissible. And in this case, I don't think the rules of evidence exceptions would really apply. But some of the rules of evidence are procedural and some of them are substantive policy. And that rule of evidence is substantive policy because, of course, how someone's acted in the past is very relevant to how they would act today. And it's generally been excluded by courts because it's so relevant as to perhaps even be distracting to the determination of whether they committed the new offense. But the legislature has the authority to step in those policy areas, and they have done so. And the legislature has said, for this kind of crime and this kind of evidence, we want the jury to know these things. And so the courts of Michigan have upheld the constitutionality of that statute, as I understand, because it is a proper exercise of the legislature's public policy and substantive policy authority. So therefore, the court would not agree with the defendant's argument that admission of this evidence would violate due process. The statute allows for it. The statute is constitutional. It still is subject to other rules of evidence. And the defense says, well, for example, you should just have to present the evidence of the victim of those prior acts to testify about what happened and not, for example, introduce judgments of conviction or registers of actions. Well, that's not, I disagree with that. The statute makes evidence of the other acts admissible. What evidence the prosecutor chooses to proffer at trial is kind of up to the prosecutor. And if they offer, for example, a judgment of sentence, well, that would be admissible as a hearsay exception under MRE 803.22. If they want to present the testimony of a victim of that, they can do that. If they want to do it through records, as long as they're otherwise admissible under the rules of evidence, they can do that. So then we've got 3 prior acts of domestic violence here, and all of them did result in a conviction. In 2023, defendant was convicted of domestic violence with the same victim as in this case. And then he has convictions in 2013 and 2014 with a different victim than this case, but both of those convictions involved the same victim. And as to the 2013 and 2014 convictions, the defense says, well, they're more than 10 years old, so therefore they're generally inadmissible, which is correct. The statute only allows evidence of other acts beyond 10 years, then doing so is in the interest of justice. And here I agree with the prosecutor that they are, because the defense is asserting that the defendant acted in self-defense and that therefore it was justified in committing an assault on the complaining witness. There's, the prosecutor's entitled to say, well, the jury could be, if the defendant is claiming that he's not an aggressor he's only defending himself, then I think it's fair for the jury to know Mr. Bradshaw's history of acting as an aggressor and being convicted of acting as an aggressor in domestic, in the context of a domestic relationship. So I do think the interest of justice exception in light of the defense proffered by the defendant is applicable here. And then the defendant says, well, these are just too prejudicial. Well, they certainly are prejudicial to him, but the question is, are they unfairly prejudicial? And is the danger of unfair prejudice, does that substantially outweigh any probative value? Here, the probative value is quite high, even though there aren't a ton of really striking similarities between the offenses. When I look at the Watkins factors as a whole, here they are very reliable because they all three resulted in a conviction. Many times these other acts evidence is where now comes out of the woodwork every allegation that somebody wants to level against a defendant that occurred in the past, and there's zero documentation of those events having actually taken place. This is on the far opposite end of the scale. Each of those prior acts was documented, was charged, and did result in a conviction. Also, I think that the defense makes a great point that convictions more than 10 years old are generally not allowed because people change over time. But here, Mr. Bradshaw apparently has not, because more than 10 years ago, he had a couple convictions for domestic violence. And then only 2 years ago, he had another conviction for domestic violence. So that shows a consistency in the defendant's character and behavior over an extensive period of time. So that's very relevant. In terms of the temporal proximity or infrequency of the other acts, that there's sort of a continuing timeline in Mr. Bradshaw's life that shows that his becoming physically aggressive while intoxicated to people he's in a domestic relationship with is really sort of a feature of the arc of his life. So I think that when I consider the Watkins factors, that's important. And the need for the evidence beyond the complainant and defendant's testimony, especially again, in light of the claim of self-defense, I think it's important that the complaining witness's testimony be allowed to be bolstered by the prior acts that are reliable and resulted in convictions. So therefore, the prosecutor does have the burden of showing that these other acts are admissible under the statute. I believe they have met that burden, and I'd overrule the defendant's objection and hold that the other acts evidence contained in the prosecutor's pretrial notice would be and will be admissible at the jury trial on June 2nd. All right, and with that, Mr. Pyle, are there any other pretrial issues that you anticipate, or are we ready to go on June 2nd?
Not at this time. I just have, will the court issue a order, or will we be able to order a transcript?
Well, yeah, you can order a transcript of this hearing for sure. I guess Ms. Goodrich, as the prevailing party, would you submit an order?
Yes.
And I know Mr. Penanti had discussed the possibility of an interlocutory appeal. So if you, I'm sure you'll consult with him later today or this week. If you can, if there's anything that's going to be happening that would throw the June 2nd date into jeopardy, if you could please have him contact Ms. Goodrich and arrange for a telephone conference with me in chambers at his earliest opportunity so that we can sort that out. But otherwise, we are still scheduled for a jury trial on June 2nd. All right, anything further from the defense?
No, Your Honor.
Anything further from the people?
No, Your Honor, thank you.
Okay, thank you. Have a good day. And I think we're good until 10 o'clock.